Hello, everyone, and welcome to this webinar. We're going to give folks a minute or so to start joining us. But in the meantime, and this is a reminder for the rest of the hour, you can use the chat box to say hi to us, let us know your name and where you're coming from. I know we have folks coming from all over the place, across California, across the country. So drop your name and your location in the chat box. And throughout the presentation, feel free to drop in comments or questions for our presenter, Hannah, today. We have some Q&A time set aside. And while we're waiting for folks to join us, I want to introduce or welcome back Anjuli from John Paul Stevens. Hi, how are you doing?
Hi, good, thanks. Hi, everyone. So happy to be here.
We're so happy to have been able to do this three-part legal skills series. We started like a month and a half ago now, and it's been really great. I've learned a lot, and I know we've gotten some really great feedback. And this idea was originated by our fellows and scholars who specifically told us that these topics were useful and that they felt that they could learn more about it from what they learned in law school. Welcome, Neri. So just a reminder, let us know who you are and where you're coming from. Hi, Salashi. Nice to see a lot of familiar names. Drop in your name and your location in the comments. And now we're going to get started. So I'm going to introduce our instructor, Hannah.
Hi, my name's Hannah. I'm going to be giving this presentation on issue spotting and case management. I don't know, Carlos, did you want me to give a little bit of background of myself?
Yes, please. Great. And let us say bye to everyone, and you'll take over.
Okay, so yeah, I'm going to be talking today about issue spotting and case management. And so a little bit about me, just to kind of give you guys a background of where I'm coming from, because this topic is very broad. It's something that it's very hard to give specifics, like specific tips, without knowing what area of law you practice, because it can vary depending on what types of cases and what types of clients you're working with. And so I wanted to give a little background about where I come from and the perspective I have, so that way you guys can kind of understand where I'm coming from. And while I'm doing that, if you guys wouldn't mind putting in the chat what year you are, if you're still in law school, or what year you are practicing, so that way I kind of have a sense of how much experience you have and where you're coming from. So I work for Texas Rio Grande Legal Aid. It is a legal aid that covers South Texas and up to Central Texas and all along the border. And so it's a pretty large legal aid. There's something like 400 employees. So there's quite a few attorneys and quite a bit of staff. So I kind of have this, some of the tips I have may not apply to you if you're working for a smaller firm, because I have lots of mentors and people who have been practicing for years and years. And so there's already like pre-planned protocols and stuff for the organization that I didn't have to come up with myself, because other attorneys have been doing this in the same organization before me. So that's something that I have, that if you work for a smaller org might not happen for you. I also, I started initially, I wanted to do family law, and then because I practiced in Texas, I graduated in 2017, and that was the same year that Hurricane Harvey hit the coastal Bend region. And because of the impacts of Hurricane Harvey, I started doing disaster work, and then that carried on for several years, and I really liked it. And then I started doing title clearing and probate work, and now I am the head of the guardianship team at Trala. And so I've been practicing for like 6 years plus, and it's been a journey to where I am now. So that's the other thing about me. I also work for low-income clients, which I think is the idea behind most of where you guys will work as well. So to get into what issue spotting and case management are, I wanted to just highlight first that this is different when you are in law school than it is when you're in practice. So most of you have probably heard the terms issue spotting, maybe less about case management. But because issue spotting is, what you do in your exams and what you do in your classes. But it really means a different thing in practice than it does in law school, or at least it's applied in a different way. Because issue spotting, when you're in law school, you're given this fact pattern. You can't really go outside the fact pattern. You kind of have to stick within those facts. And it's almost the opposite in practice, where your client is going to give you this much information and you have to kind of dig in, and you have to know what to dig into and know which questions to ask to get the information that you need in order to spot the legal issues that person has. And so it's very different. It's a very different skill than what you're taught in law school. And then case management is something that I really just don't think, in my experience, people do in law school at all. In your summers, you may do some version of case management, but the thing is, case management's really easy when you have like 2 cases. Case management only gets difficult and hard, and you have to actually come up with systems when you have a full caseload, because that's when you have to sit down and figure out how to prioritize your clients. Because if you have 3 clients, then figuring out what to prioritize is not really that hard. It's only when you have 20 clients that you have to really start figuring out how to manage your time right. So is there something that unites case management and issue spotting? Obviously, I wouldn't have asked this question if the answer was no. So the answer is yes. And I think that the thing that unites it is client communication. So working with clients is also something that you don't usually get a lot of experience in when you're in law school. And it's really something that you have to kind of learn more about how to do once you've started practicing. So I do want to say that I think the issues on this particular slide, I think, are not really just applicable to low-income clients. I've never worked for a big law firm or a corporate law firm or anything like that. But from the conversations I've had with people who do and who have, these kinds of issues happen pretty much no matter where you work, because this is just what working with clients in the legal field is like. People who have not gone to law school don't understand legal issues, and they can be really, really smart and have a lot of knowledge they're not necessarily going to understand the law. And the way I usually look at it is, the legal field is a very specialized area, in the same way that, like, being a construction worker can be highly specialized. And I would have no idea how to do some of the like plumbing things that people do, because I haven't spent 10 years learning how to do it. But the people who are fixing my toilet have spent 10 years learning how to do it. And so I think it's very similar. I wouldn't expect the plumber to know how to solve, the probate issues I see. And wouldn't expect me, he or she wouldn't expect me to know how to fix the plumbing, because we have our own specialties. And so we do our own thing. We've spent time learning how to do it. And so it's really not about, your intelligence. It's just about your knowledge of legal issues. And I also think, when I was in law school anyway, they told us, we're teaching you how to speak like a lawyer, how to think like a lawyer. And when I was in law school, I didn't feel like there was a significant change happening in my thought process about the law. But then, and most people I've talked to have a similar experience, sometime in usually 1L, you'll be in a conversation with a family member, and you'll say something, and they say something about the law that you're just like, oh, that's wrong. And you're like, I don't even know how to articulate to you why that's wrong, but it indicates a lack of understanding of how the law is made. And that it was very jarring for me when I had that conversation. And it was with my mother, and she was just talking about a new law that had passed. She was just like, oh, well, we'll figure out what the law says. And I was like, well, yeah, it's going to go to court, and then the judges will figure out like what it is. And she was like, what do you mean? And we just had this weird back and forth where I had this moment of realizing that she just didn't understand like judicial interpretation at all. And it is a bit weird when that happens. So your clients have not gone to law school. They're going to be confused about legal issues, and you shouldn't expect them to know the process, because they won't. They will also probably be frustrated, which is understandable because the process is often very frustrating. You'll talk to clients who are like, but this is what happened. Like, I know that that's what happened, but we have to prove it to a judge. And in order to prove it to a judge, we have to be able to like present the facts in a way that makes sense. And the client may be quite frustrated with that. Again, understandable, because it is frustrating as an attorney that if you can't find the evidence to support the facts that you know to be true. You will have sometimes trouble with consistent communication. I think this issue is more difficult when you're working with low-income clients, because you're more likely to have people who have moved houses, who've changed their phone number. And so it's a little harder to keep track of people, but it's just something you have to remember to stay on top of. So working with clients with trauma, you may not end up working. I do not think it's fair to say that every client at every legal aid is somebody who's traumatized. Obviously, the origins of my work was Hurricane Harvey recovery. Most of my clients did have some level of trauma. They'd lost their home. They'd lost kind of everything that they had worked for. If you're working with domestic clients who are victims of or survivors of domestic violence, most of your clients are going to probably have some trauma. So it depends on the area you're in, but you can end up seeing clients who do have a lot of trauma. So there are some special considerations. There's whole presentations you can watch about working with clients with trauma. But generally, they might have trouble focusing. They might have trouble prioritizing, or at least aligning their priorities with what you think their priorities should be. That doesn't mean they're not prioritizing. It just means they're not prioritizing in the way you think they should. And I would say it's not inherently true that you are the one who's correct in that situation. It may be that their priorities are more accurate for what they actually need, and you're just not understanding that. That does happen. They're also more likely to miss deadlines because they've just got a lot going on, they've got too much to process, and they may shut down. They may have this fear of obtaining assistance. This happened a lot with Harvey work, where you would get the money for the client, but they don't really want money. What they want is not to have lived through this disaster, and that's obviously, you can't make that happen. And so even once you get the aid for them, there tends to be kind of oh, okay, great, and they just don't really process it. So they may avoid talking to you because they are scared of what will happen if they actually get the money, or whatever the relief is that they're seeking. So be accommodating whenever you can, and keep your communication open and often with your client. So try to be in touch with them often to make sure that they haven't just make sure they don't think you've forgotten about them. Make sure they know you are still working on their case, even if nothing has happened really in the last little bit. I will say, on being accommodating, one thing that's very difficult when you're a new legal aid attorney is learning how to let go of a client that's not responding to your assistance. One of the very first things that my mentor, during one of my summers, one of the things that she told me was, you can't care about a client's case more than they do. And when she first said that, I was kind of like, that's a little harsh, but it is very true. And when you practice for a while, you'll see, like, sometimes you get a client that you think, if we could just do this one thing, it would fix their legal problem, but they are just not interested in doing that. And you have to remember that it is their life, and that you don't, it's patronizing to expect them to want to live their life the way, they're not you. They're a different person than you. They have their own goals, their own priorities, and they may not align with what you think their goals should be. But again, your goals are not necessarily the right goals for that person. And so you should let the clients do what they're going to do. And to try, be accommodating. That's not to say, if someone's like, I've met with clients, after hours, if somebody's like, I work 8 to 5, I cannot get off, I can meet with you at 7 p.m. Obviously you have to have some kind of work-life balance, and maybe you can't do that for every client, but try when you can. I would encourage that, to meet clients where they are. But if you've set 7 meetings for a client and they've not shown up and they haven't called you and you can't get them on the phone, it's time to move on and close that case, because you could have helped 3 clients in the time you spent tracking down 1. And that is a very difficult thing to learn. I will say it's kind of heartbreaking to learn it, but it is something you have to figure out how to do. Okay, so then going to issue spotting, I have a brief hypothetical that I'm just going to read and then run through. It's not really meant to test you guys. That's not the point. This is just more, this is kind of looks like what we get in a case description on our intakes. And then I want to run through the various issues that may come up in it. So the hypothetical is client calls because she's seeking assistance for repairs for her home. The agency is telling her she doesn't own her home, but she purchased the home with her husband who passed away about 6 months ago. Client's confused because she believes she owns the home now. So that is not significantly shorter than most case descriptions I get. That's your case. So now you get that, you've made sure they're eligible for your services, you've made sure there's no conflicts of interest. So now you have to figure out what you're going to do for the client. So my first steps here, again, if you guys don't practice probate, none of these steps might not seem like they make sense to you, but this is what I would do. Is you look in the deed records, you learn she and her husband are both named on the deed. There's a remaining lien on the property, so that there's still money owed on the property. You also check the tax office and learn there's a tax debt of $5,000 pending. So now what do we do? So there's a bunch of legal issues. I'm just going to go ahead and run through them for the sake of time. But obviously there's a title clearing. She doesn't own the home. A lot of people in Texas, anyway, I don't know how it is in other states, but a lot of people in Texas assume that if you're a married couple and one of the spouses dies, the other one has inherited the home. That is not the way it works in the state of Texas. You have to set stuff up so that happens. So the title's going to need to be cleared potentially. This lien might need to be released. Does she actually still owe money? Perhaps, and I've seen cases like this. Perhaps the debt's been paid, lien has been paid off, but the bank or whoever it was that held the lien never released it. So we need to work on getting that done. She has this tax issue. Can she defer? Can she, does she have the ability to get on a payment plan so that it can be paid back? Estate planning for the client. This one is less critical, but I usually, if I'm working on a case like this and I get everything nice and neat for them, I want to then talk to them about, do you have someone you would want to get the property? So that way we can go ahead and take care of that now. And we don't have to, your children or your brother, whoever's not calling us in 6 months because you've passed away and now we're in the same position. So can we estate plan for you so that this doesn't happen? And then working to get the disaster assistance to repair the house, which is of course the actual ultimate goal. So there's a lot of different issues from that very short piece of information that might need to be teased out. And you're going to have to ask questions about each one of those issues in order to really dig into that client's case. So some broad tips about issue spotting. Again, it does depend on your legal expertise in your legal area as to what issues will need to be spotted. But the most important thing is to talk to your client. Once you have gotten a bit of experience and you know which questions to ask, you may be able to do more kind of communicating through a paralegal. I would advise to do a lot of it when you can yourself at the beginning, unless you have a really experienced paralegal. But because you need to really get the full scope of what's going on in their case. And so I try to go in depth into issues. Obviously, there's a limit. If you've been practicing for a while, some clients are chatty and they may start going into details that really are not relevant. So you can, at a certain point say, bringing us back to the eviction that we're talking about. But I try to, I let clients go for a little bit when I have the time, because they may say something that they don't realize is relevant to the landlord tenant issue, but that is. And so that can be very tricky to do. Kind of just let clients go for a bit until you hear something that is relevant. And I also say I like to ask questions in different ways, because sometimes what you think you're asking is not what the client's hearing. And the example I use for this is one time I was doing an affidavit of heirship for a client who was very sweet and I do not think was trying to lie to me at all. But an affidavit of heirship is a probate type document that you can do in the state of Texas. And so you have to gather information about heirs. And so I was asking her, it was her parents that had passed away. I was asking her about her siblings. And so we've gone over this multiple times at this point. We already had the document prepared and she had given us all the names of her siblings. And so I'm doing the actual final, I was planning to close the case that day, doing a final check of the document. And so for the first time, instead of saying, tell me, name your siblings, I said, what's the name of your oldest sibling? And she said, oh, so-and-so. And she listed the name I knew. And then she was like, oh, well, and then I had an older brother, but when he was about 12, he left. I think he was adopted or something. And I don't know where he went. We never heard from him again. And I was like, oh my gosh, because now I'm going to have to figure out who this person is and where he went and what happened and, blah, blah, blah. And it was the client, she was like 3 years old when he went away. When I said, name your siblings, she didn't think of him as a sibling because she had no knowledge of him. And she doesn't know the law. She doesn't know that he's still an heir because in her mind, he's not a sibling. So again, not her fault. She gave me as much information as she thought was relevant, but she doesn't know necessarily what's relevant. And so it's up to you. Your job as the attorney is to get that information. So ask the same questions multiple ways to try to get at information, because even clients that are trying to be helpful may not know. And then think outside the box, try to see if there's ways to prevent future problems with the legal work that you're doing now. Try to see if there are other problems that may, underlying problems that may have created the problems the client is currently facing, and see if that can be addressed. Again, that varies depending on the area you're working in. Keep the goal in mind. So again, with that original hypothetical, the real goal was a disaster assistance, right? And so yes, there's this lien that should probably be released, and there's this issue with the title not being clear. What needs to be done to comply with getting the disaster assistance? That's the goal. Now, obviously you can't do something unethical. So if there's a shortcut and there's something that maybe, because we've seen things like this, it would get them the disaster assistance, but it's going to leave their title a little messy. As long as it's not unethical, you can talk to your client and say, you can do this quit claim deed. It's really not ideal, and it could cause you problems with title down the line. But if you're willing to take that risk because you want your house rebuilt, understandable, and you can't live in a house that's damaged for the 2 years it's going to take us to clear your title, you could do this. And if you advise the client, again, it's their decision, it's their case, it's their house. As long as you provided the legal advice and informed them of that risk, and if they want to take that shortcut, then, and potentially deal with consequences to the title down the line, that's up to them. Your job is not to, monitor their decisions for them. Your job is to make sure they're advised of the law and able to make an informed decision about what they want to do with their situation. So keep the goal in mind when you're working on cases. And then it does get easier. It's very hard to issue spot when you don't know your area of law very well. So every attorney has a story where they've been practicing for 18 months, and then they're talking to someone and that person says, oh, well, did you check XYZ? And they're like, you're like, I don't even know what that is. What did I check what? I've never even heard of that. But now you have heard of it, and the next time you'll remember to check it. And it does get easier as you keep practicing. So when that happens, and it's okay, go home and have a cup of tea or a drink and relax, and next time you'll be better. And don't beat yourself up about it, because it does happen. So case management. This is even more broad than issue spotting, because again, if you're a landlord-tenant attorney, you may have 40 cases at a time. If you're a family law attorney, you may have 12. It really depends on the area of law you're practicing in. Landlord-tenant cases often move very quickly. Immigration cases move very slowly. You could have the same cases open for 5 years potentially. So it is difficult to give general tips, but some general tips that I have: try to do regular case reviews. This can be hard, and sometimes you'll have cases. So for example, in the state of Texas, when you probate a will, you have to, under certain types of probate, you have to post something in the newspaper, and then basically creditors have a certain number of months to respond. So there's not really a lot of steps once you've posted that newspaper, that notice in the newspaper. All you're doing is waiting for that deadline to pass. So those types of cases I check on like once a month, because probably the client has been told to call me. The client knows that I'm not going to be calling him. And I'm just waiting to see if anything has happened. That one doesn't really need a lot of check-in, but you want to check on it still occasionally, because what happens if, my client calls and he gets a paralegal and he tells the paralegal logs it in the case, but forgets to hit send on that email. Now I don't know that this has happened because I haven't looked in the case. So check your cases when you can, to make sure that there hasn't been something entered that you aren't aware of. Don't take too many cases. Obviously, this is one, depends on where you work, as to whether, you're allowed to not take too many cases. It's also difficult sometimes when you're first starting out to adequately kind of evaluate or correctly evaluate how long a case is going to take. So you may think, oh, I have time for other cases. And then you take other cases and one of the ones you were working on blows up and you're suddenly completely swamped. That does happen. So try to avoid taking too many cases. Obviously, some organizations are going to kind of force you to do that, and there's not a whole lot you can do about that. But don't take. Try to prevent that from happening when you can. I recommend people, when possible, do tasks yourself the first time, because again, it's sometimes, at least for me, it's hard to tell how long something's going to take until you do it. And I don't want, you may have a paralegal who's very an expert in that area, and get templates from them by all means. Ask them to review your work if they're really an expert in it. But I like to do it myself first, because in that way you have a deeper understanding of how to do it and you could teach someone else to do it. And then that way, if that paralegal quits or goes on leave or something, you aren't like, oh my gosh, I don't know how to do any of my work. So I always recommend doing things yourself the first time when you can. Learn how to delegate. Again, once you learn how to do it, once you've done it yourself 2 or 3 times, now make sure you let the paralegal handle it, when you can. And talk to your client often. Again, it doesn't have to be all the time. And there's other presentations where people will talk about setting boundaries with your clients, because clients will call you 4 times in a row. And almost never is there anything so urgent that you need to respond right then. Usually you can respond the next day or even the day after that. So don't think if you're in the middle of something and someone's calling you that you can let them leave a voicemail and call them back. Almost always. It's usually not necessary to take every single call from your clients, because clients will be panicky, but it's not necessarily something that you can address right then. So, but you should talk to them fairly often, because sometimes, again, speaking of clients not knowing necessarily what's relevant, sometimes you'll be talking to a client just to check in and they'll tell you, oh, and I got this notice from someone, but I don't know if that's relevant. And maybe it is, maybe it's not, but now you at least know. And they may tell you about developments that they didn't think were necessarily important. And sometimes clients think you're smarter than you are. So sometimes clients won't tell you something because they'll just be like, well, I assumed you knew that this would happen, so I didn't think I needed to tell you. So checking in with them to kind of say, has anything happened? Have you received any letters? Is something that can help you stay on top of your cases. So how to prioritize cases. Another thing that one of my mentors told me when I first started practicing was, don't let the squeakiest wheel get the grease. You will have clients that call you twice a week. And then you have clients who do not call you at all because they expect you to call them. And just make sure that you don't, you can, if necessary, maybe the client's calling you twice a week because their case is moving very quickly, but don't let the fact that they're calling you push them in front of someone who actually has a more urgent matter than they do, just because that person's trying to be respectful of you and is not calling you. Try to actually look objectively at what's the most critical case, what's the case that needs to move fastest, and try to prioritize based on that and not based on who's calling you, it's very easy to fall into this client called me, let me just work on their thing real fast. But it's not, in the long term, it's not an effective method of prioritizing your cases. Obviously, keep track of your deadlines and don't let your cases get stale. Check on them, fairly often, so it's not just sitting around waiting. Time management. This is so broad. Figure out something that works for you. I'm a big proponent of a bullet journal. I discovered it in 2020, I think was the first year I did a bullet journal, or maybe 2021. And I had tried multiple methods before then, and kind of none of them had worked super well for me. I love my bullet journal. I think it's wonderful. It's very customizable. Depending on some of my workload changes, I can customize it to that change. But people use weekly to-do lists. One of my coworkers has one of those big like computer pads that you get that is like Monday, Tuesday, Wednesday, Thursday, and just like starts a new week every week. Some people use online task managers. I would say just play around until you find something that works for you. And it may take a while, but eventually you'll find something that works well. Communicate with your client. I think I've stressed this enough, so I won't go into much more depth about it. But make sure your client is aware of what you're doing in their case. In Texas, I don't know about in other states, but I feel it's probably similar. But in Texas, I think the largest single reason that people get in trouble with the bar is lack of client communication. So, you know, if something happens in a client's case, let them know. And in my experience, because I've had it happen where I tell a client, I'm going to try to get this done by this date. And then I have another case kind of go south. And so I don't get to it. And usually when you call that client ahead of time and you say, I'm sorry, I told you I was going to try to get it done by this date. I have another matter that's become really pressing. I'm going to need another month to get that done for you. Most of the time, clients, even if they're a little upset, will be understanding. So just let your client know, this is where we are. This is how long I think it might take. And I'm working on your case. I haven't forgotten about you. It's just taking me a little bit to get it done. And then most clients will be happy with that. And then again, said this earlier, it gets easier. I mentioned earlier, it's difficult when you first start to know how long things will take because you haven't done it yet. That also gets easier. You'll start recognizing, you know, this particular court responds, you know, it takes 3 weeks to get this one court to sign orders, when normally with other courts it takes 2 days. And so you'll learn to be able to tell your clients to expect that. Like, every time we appear in front of this judge, it takes us 3 weeks to get the order, so it might be that long until we get your letters testamentary. I'm sorry, there's not much I can do about that other than wait for the judge, because I can't force them to sign the order. And then, you know, and your client knows. And so you haven't, you know, because you'll find yourself in a situation where you tell your client, oh yeah, the judges sign these in like a day. But then you're in a new county and this judge doesn't sign it in like a day. And so now you've told your client this, it's not true. And that kind of thing happens. And so as you learn more and practice more, it does get easier to kind of know how long things are going to take, to know how to prioritize your clients and their cases. And it does get easier. I also often tell people that this is my last slide. We'll move to questions in a minute. But I also tell people that, to me, learning to practice law, I usually use the example of it's like learning how to drive a car. The first 2 years, having watched other attorneys, legal aid attorneys come and go, and people leave the legal practice after 2 years, I think the 2-year mark is about where it starts getting easier. And I compare it to driving, because it's when you first start driving, it's hard to tell like how much pressure to put on the brake pedal, you know, to slow down in a curve, because you're not familiar, and you have to still consciously think, I need to turn my blinker on, I need to do this. But eventually, you know, if you've been driving for a while, you probably don't even remember the last time you thought about turning your blinker on. You just do it. So then you can start actually focusing on the road, because you learn how to do all of that stuff automatically. So you'll learn how to do your conflicts checks, how to send letters, how to, you know, contact the Medicaid State Recovery Program, how to do all of that stuff until it's like routine. And then it can get, those issues start being less stressful. And now when a client comes in, you know how to check all the regular stuff. And so now it's like, oh, this is a weird, I've never seen a will that has this one weird provision. Let me go look into that. That's interesting. And you can actually focus on the legal issues as opposed to like the routine stuff. And it gets much more bearable. But the first 2 years are really hard, I will say. But it does get easier if you stick it out. So are there questions?
Let's give folks a little bit of time to type in their questions, but thank you so much for this. I think that I was listening to you say some of these comments, and so many of the things you brought up could be like their own like thing, right? Their own presentation, like the trauma
Yes.
and like knowing like when is enough or like how to say no. Like I think that's a huge skill that I'm still learning how to do. Like how do you say no when every part of you wants to like say yes even though you know you can't do it.
Yeah. And it's really hard. And you have to like remember that if you're taking a new case, that's less time spent on the cases you already have. And so you have to think about like, I could tell this person I'm going to represent them, but am I going to be able to represent them well if I take this case? Or am I going to end up messing up two clients' cases instead of just devoting myself to one? And it is hard because when you work for legal aid, there's usually not another organization that can take that issue. And so if it's not you, it might be no one. But sometimes you just have to say no, and it is very hard. But if you practice that, it does get better.
Yeah. So just a reminder for folks to drop in any questions or comments. Hannah's here to provide feedback. I did see that earlier in your presentation, someone said that sometimes clients will tell you one thing and then a paralegal will tell you something else. You talked a lot about communication. Any like specific tips about how to handle situations like that?
Yeah. So if the I mean, I think that could be a lot of things. I would want to know, maybe the client might be scared of you. That could be one, and that's why they're telling the paralegal something different. I would probably, if I've talked to a client about something, my understanding was one way, and then I see a log or an email, or I talk to a paralegal and they say, oh, I understood this. I would probably just reach out to the client and say, so my paralegal, I just want to clarify, my paralegal thought you said meant this. I thought you meant this. Which one is it? Maybe the client was just not not understanding the question. Like I mentioned earlier, maybe they were answering the question honestly. You guys phrased the question differently. And so they're both things are true. Or maybe they remembered something in the second call. And so they were like, oh, I said this, but actually the timeline was wrong or whatever. And so it could be nothing really. It could be just something that you have to clarify. And I see that the comment is that lots of trauma and no familiarity with the legal system. So I think that makes sense. And trauma also, I didn't really get into that. I don't think I put that on the slide, but there are trainings that people do on trauma and working with clients who have trauma, and I've been to a number of those. They're usually pretty good. But forgetfulness and forgetting like timelines and stuff is something that happens with trauma, because if you have it, so if you're trying to get like a timeline from a client who's a survivor of domestic violence, that may be if it's been 2 years, that may be very difficult to do. They may talk to you about like, well, I did this, and then, the opponent did this, and then I went to the hospital, and then you get the hospital records. It's like, no, you went to the hospital 48 hours later, but they just don't, because the trauma has like rushed all those memories into one. It doesn't mean they're lying. It just means that's what your brain does to protect you. A lot of times is it kind of throws some of those memories out. So it can be difficult.
Yeah, I'm glad you brought that up. I know that John Paul Stevens has talked about like trauma, like trainings on how to handle trauma, but also like secondhand trauma that you as a lawyer can sort of absorb, which I know is like a very big part too of the trauma conversation for lawyers.
Yes, and that is something that so one time that I did this presentation, I actually had someone ask me about disaster work versus probate work and which was more traumatizing. And at the time I said disaster work was more traumatizing. But the probate work can be somewhat traumatizing as well. It's a different type of trauma, but you do start to see like people grieving and then people fighting over, because you realize after a while, you're like, none of these people most of the time, these people are not actually fighting over this resource or this asset. They're fighting over like the death of this, matriarch of this family has destroyed the family. They want her china set or whatever because they want her back, and that's not going to happen. but you don't. So you want to just grab your client or the opponent and be like, do you know that this will not bring her back? But you can't do that, obviously, and it can be a lot to manage. And I also did after the Uvalde shooting at the school, we did a lot of work on that, and that was extremely traumatizing. So it can be legal work can be traumatizing. So I would recommend, if you've been practicing for a few years, you may not think that you are getting secondary trauma, but talk to your family and friends, and so they may have a different opinion about your anger issues that have come from the work you do.
Yeah, it is. It's unfortunate. You see it a lot in the profession, and that's why we want to bring folks like you on here to talk to folks who are on their way into the profession or have just started, to at least I don't know, reduce the stigma of just talking about this stuff. Well, I think that's it for today. And Julie, do you want to close us out or anything?
Yeah, well, I just want to thank Hannah for your time, and I agree totally with Hannah. I practiced public interest law for 16 years, and I think that having repetitive trainings, especially on vicarious trauma, is always a good idea, because just reminding yourself of the tools to be able to continue to be resilient in doing this work is so key, and being able to support attorneys going out there starting their career off with the right tools is all we can hope for. So thank you, Hannah, for your time. So appreciate it. Thank you, all of you, for joining us. And we look forward to seeing everyone again.
Thank you so much, everyone. We'll send a follow-up email with some resources, including Hannah's slides. Thanks. Have a good one. Thank you, Hannah.
Thank you. Bye.